Good evening. Good evening, everyone. This is Dhananjaya Padmanabhachar. Heartily welcome to all participants on this important session called Apartment Association Panel Discussion. And we have an eminent guest, Mr. Sudhir Pillai sir and Chak sir, Chakrabarti sir on the call. And welcome to everyone on this call to learn and to experience what is actually happening in the apartment. Request ma'am to go on mute. I will mute everyone for now. So the main important objective of the session is to understand what is apartment association and to understand what are the different acts that's available to protect the interest of the home buyers, and why act is important with respect to the land transfer of apartment owners rights, right? So any apartment which is getting built on a land is not getting transferred to apartment associations or the owners, whatever is the case. Ultimately, the land rights need to be protected. That's why apartment associations are very important with respect to the rights of the home buyers in Karnataka. And then what are the different departments that is responsible for ensuring the rights of the home buyers? And any questions that arises in the minds of the home buyers, feel free to ask, because this is an open platform. This is an open discussion that we wanted to have with our experts on the subjects, and both the eminent personalities are with us. And what I do is, before any program starts, it's a good practice to start off with giving an introduction through a video platform. So what I do is I will run through one of the important video of home buyer struggles, home buyers pains that's experiencing in Karnataka because of the failure of the system and because of the failure of the RERA authorities in Karnataka. I wanted to walk through one important video for everyone. Request everyone to be on mute and then watch the video, and then we'll kick off the session officially with introduction of our eminent guest. Thanks a lot. Thanks a lot, viewers, for watching The Pains of the Home Buyers. ಕನ್ನಡದಲ್ಲಿ ನ್ಯಾಯ ಎಲ್ಲಿದೆ, ನ್ಯಾಯ ಎಲ್ಲಿದೆ, ನ್ಯಾಯ ಎಲ್ಲಿದೆ ಅಂತ ಕನ್ನಡಿಗರು ಕರ್ನಾಟಕದಲ್ಲಿ ವಾಸ ಮಾಡ್ತಿರೋದು ಎಲ್ಲರೂ ಸಹ ಒಂದೇ ಪ್ರಶ್ನೆಯನ್ನ ಕೇಳ್ತಿದ್ದಾರೆ, ನ್ಯಾಯ ಎಲ್ಲಿದೆ? ಮೊದಲನೇದಾಗಿ ಈ ಒಂದು ಕಾರ್ಯಕ್ರಮ ಶುರು ಮಾಡೋದಕ್ಕಿಂತ ಮುಂಚೆ ಈ ವಿಡಿಯೋವನ್ನ ನಾನು ಪ್ಲೇ ಮಾಡೋ ಮೂಲ ಉದ್ದೇಶ ಏನಂದ್ರೆ, ಎಲ್ಲರಿಗೂ ಸಹ ಕರ್ನಾಟಕದಲ್ಲಿ ರೇರಾ ಇಂಪ್ಲಿಮೆಂಟ್ ಮಾಡ್ದಲೇ ಇರೋದ್ರಿಂದ, ಸರಿಯಾಗಿ ಇಂಪ್ಲಿಮೆಂಟ್ ಮಾಡ್ದಲೇ ಇರೋದ್ರಿಂದ ಎಷ್ಟು ಜನ, ಸಾವಿರಾರು ಜನ, ಲಕ್ಷಾಂತರ ಜನ ಕಷ್ಟವನ್ನ ಅನುಭವಿಸ್ತಿದ್ದಾರೆ ಅನ್ನೋದರ ಒಂದು ಚಿಕ್ಕ ತುಣುಕನ್ನ ನಾನು ಇವತ್ತು ಪ್ರದರ್ಶನ ಮಾಡಿದೆ. ಲೆಟ್ ಅಸ್ ಆಲ್ ಆಫ್ ಅಸ್ ವೆಲ್ಕಮ್ ಎಮಿನೆಂಟ್ ಗೆಸ್ಟ್ ಆನ್ ದಿಸ್ ಪ್ಯಾನಲ್, Mr. Sudhir Pillai sir and Subrato Chakrabarti sir on this platform to discuss about the fundamental issues that we are facing. Before we start off and handing over to Sudhir sir or Subrato sir, I wanted to give a brief introduction about both of these gentlemen through a small presentation. Please bear with me. Please let me know if the screen is visible. Sudhir sir, is the screen visible?
Yes, it's visible.
Okay, thank you. So another important aspects today is Ivattu Vishwa Manava Hakkugala Dina, International Human Rights Day. So we are conducting this event on this International Human Rights Day. Home buyer are also human beings. That is the message I wanted to convey on behalf of Karnataka Home Buyers Forum. We want to protect our rights. We are also human beings. This is a message I wanted to convey to the Karnataka government. So this is my small introduction. IT entrepreneur, IT employee in a company, and founder of multiple NGOs, namely Discussion Class, Netaji Subhash Chandra Kattebalaga, and Principal Secretary for Mantri Senate Home Buyers Forum, and starting Karnataka Home Buyers Forum with the like-minded people, and then served in many NGOs and written a lot of articles, and then published a book as well, and an eminent panelist in a lot of media channels, and importantly student counselor, and work with a lot of counseling on student side as well as a lot of issues, family issues and stuff like that, and then worked on many social evils that exist in the society, including a lot of scams that happen in the past, whether it is a cooperative society scams, whether it's online loan app scam or a bet scam, or a lot of scams that's happening across the society, including RERA and apartment owners' rights on UDS scam or UDA scam, whatever, right? So some of these scams that we have worked together with a lot of our teams to expose these and then find a solution, working towards a solution. Some of them we got solution. Some of them is a in-progress solution that we're working together with a larger interest of the team as well, and with the 20 years of social service experience. So that's a background of myself, and we have an eminent personalities, Rear Admiral Sudhir Pillai sir, who served in Indian Army, and we have Sri Subrato Chakrabarti sir, an serial entrepreneur and a Home Buyers Association expert on this platform. A small introduction. Rear Admiral Sudhir sir is an ex-Indian Navy officer, a retired Navy officer who served for the country for about 37 years and retired in 2017 to serve for the people within the country. So he served for the nation and to protect us in the borders in Indian Navy for 37 years. Now he stepped into protecting the people who are struggling in the journey of having a proper home with the proper legal rights on home buyers, and an expert in management of real estate and allied infrastructures like airports, ports, hospitals, schools, and base residential housing, etc. And an excellent researcher in RERA, COVA, and COFA, DOD, or cooperative societies, housing societies, and apartment handover process. These are his research areas, and many more like Property Transfer Act and etc., which is aligned to it. And an expert in all the legal matters in terms of acts, and going detail about the acts, permissions, and then worked on a lot of issues in these areas from past many years after his retirement from Indian Navy. Thanks a lot, Admiral Sudhir sir, on this platform, and heartily welcome to Karnataka Home Buyers Forum panel discussion on this platform. And we have Mr. Sri Subrato Chakraborty, sir, who is a serial entrepreneur and run manufacturing industries in multiple locations, Hyderabad and Bangalore, and an expert in Home Buyers Association, and worked with Sudhir sir and other Ameya sir and Commander Surendra sir and etc. Who are fighting for this from many, many years. Hardly welcome to both of you, sir. Probably, I will just go through some before we go into the next step. So I wanted to, put a video of both of you, sir. I want to bring both of you on a focus area. Just to give me a second. I'm going to add the spotlight. And yeah, Subrato, sir, and spotlight. Yeah. So let me know if all three are visible. Yeah, I can able to see. Okay, thanks a lot, both Subrato sir and Sudhir Pillai sir. So before we start with the panel discussions and going through some of the important questions, I wanted to set the context. I think this is the second, you can see that in the panel also, you can see the number 2 here. So that means this is a second session that we are working, that we are presenting on social media about the apartment association. So it's important that, we set the context right before we open up the discussion with our panels. Okay. So let me share, I will continue the slide pack. So what is an apartment? So it's a very important, terminology that we are seeing in Bangalore, which was not seen earlier 80s or 90s. So after, 2000, afterwards of 20 years or 2 decades from now to before that, there was nothing called apartment. Too many apartments were existent, right? Right now, it's all about independent houses, and everybody will have a BDA allotted site or a revenue converted site where people used to construct a house. But the concept of apartment, we borrowed it from Mumbai and other parts of the country. And we started building, having multiple houses within a small building, right? So a small building or a bigger building, right? So you can see an image on the side. So this is, we call it as a dwelling units. A building containing more than one dwelling units, most of which are designed for domestic use, or sometimes including shops and other non-profit purposes. This is an apartment. So what is an apartment association? So whenever there are multiple dwelling units are combined together, you need to have an association to manage, right? So apartment owners association is an association where all owners of the apartments are members, and the association maintains the facilities or amenities available in the apartment. So why apartment associations are required? The first important point is to take care of the maintenance of the common areas, to work for the welfare of residents in the apartment, to conduct events or awareness programs, to protect the rights of the apartment owners. A very important point, to protect the rights of the apartment owners, where today's discussion will be revolving around this fourth point, and to defend legal action raised against the association. Very, very important points. Viewers, you need to understand why apartment association is a mandatory for any apartment. And the second question comes, is the association need to be registered or unregistered? So the law of the land says the National Consumer Dispute Redressal Commission has declared that only a registered residents welfare association, consumer organization, cooperative societies, or association of flat or of flat buyers can file complaints against the builders in the commission. So why we need to file a complaints against the builder in the commission? Because to protect your interest. Not every builder will ensure that your property rights has been transferred to you, your lands rights has been transferred to you, and complete as per the plan and handover, right? So it is very, very less than 2% or 5% of the builder community are doing this. But in Karnataka, I can assure you on this platform, with our research, till today, not even a single apartment has been transferred their land rights in the name of the association or in the name of the flat owners. Please make it a point. I want to be very open-minded discussion on this platform. When I talk about apartment land rights, whether it is transferred in the name of the individuals or in the name of the association, we want to ensure the land rights reflects the name of the owners or association, whatever is possible under the law of the land. So we have not seen any apartment association name reflecting in the land records in Karnataka. So anybody wants to make it on record, we can challenge, and we will sit with the authorities if they want to, or we can sit with the organization which claims that we don't need to transfer the land rights. It is an open challenge for all such organizations on this platform. So what are the benefits of registered association? The funds collected will be accounted. Very important, and it brings the transparency within the apartment communities. Association will be able to take action against the defaulting residents who fail to comply with the rules or delay in paying the maintenance and other important contributions. Registered association can take conveyance deed from the developers to take control of the project land title. Very important, home buyers. The third point, registered association can only take conveyance deed from developers to take control of the project land. What are the different acts that's available? I just list down as per our knowledge, and then we will debate and discuss whether it's a right act or wrong act, whatever. But these are the acts under which apartments are running today in Bangalore. Karnataka Societies Registration Act 1960, we call it as KSR in 1960. 70 to 80% of the apartment fall into this category in Karnataka, as per our knowledge. Karnataka Apartment Ownership Act 1972, KOA 1972, some of the apartments are declared that they are the associations under this act, and there are significant numbers in Karnataka as well. And another one is a Karnataka Cooperative Societies Act 1959, KSEST 1959. There are few apartments who formed an association under Cooperative Societies Act. The other provision is Companies Act 2030. You can also form an association under this act. So which is the right act, why it is right act, and all those things we will discuss with our experts. So before that, I want to bring on important aspects of some of the important orders that's passed by the government in the past. So in 2018, the Register of Cooperative Societies has circulated an order from the government saying that associations cannot be registered. Associations, welfare association cannot, apartment welfare association cannot be registered under 1960. You can see it in the order in the left side. ಅಸೋಸಿಯೇಷನ್ ಸೊಸೈಟಿಗಳನ್ನು ಕರ್ನಾಟಕ ಸಂಘಗಳ ನೋಂದಣಿ ಅಧಿನಿಯಮ 1960 ರಲ್ಲಿ ನೋಂದಣಿ ಮಾಡತಕ್ಕದ್ದಲ್ಲ. ಏನಕ್ಕೆ? ಸಹಕಾರ ಸಂಘ ಮತ್ತು ಕಂಪನಿಯಾಗಿ ಸಂಸ್ಥೆಗಳನ್ನು ನೋಂದಣಿ ಮಾಡಬೇಕಾಗಿರುತ್ತದೆ. ವೆರಿ ಕ್ಲಿಯರ್ಲಿ ಡಿಫೈನ್ಡ್ ಇನ್ ದ ಆರ್ಡರ್. ಕರ್ನಾಟಕ ಸಂಘಗಳ ನೋಂದಣಿ ಅಧಿನಿಯಮ 1960 ನೋಂದಣಿ ಮಾಡುವುದು ಸೂಕ್ತವಲ್ಲ. ದಟ್ ಮೀನ್ಸ್ ಯು ಕ್ಯಾನ್ ನಾಟ್ ರಿಜಿಸ್ಟರ್ಡ್ ಅಪಾರ್ಟ್ಮೆಂಟ್ ಅಸೋಸಿಯೇಷನ್ ಅಂಡರ್ 1960. But what happens to the 70% of the apartment who is already running this show? Very important question to be asked each one of us. Okay. And the next one is, there is an order which reference to one of the home buyer, Mr. Commander Surendra sir, who complained against the association in 2019, and an order was passed where it is clearly said the Register of Cooperative Societies in Karnataka hereby dismiss the application filed by the applicant as having no jurisdiction to resolve the dispute between the parties. The association was registered under KOA, and they're saying that I don't have a jurisdiction. Please make a note of it. This is an order against one of the complaint registered by the home buyers against the association. You can see the Register of Cooperative Society is passing an order on this. So this is the KOA 1970 Register Association. So what are the different, another two important, orders that I want to pass on to everyone. There was an activist who filed a RTI saying that he is the sub-registrar or a competent authorities to registered apartment association or owners association. The answer is no. ತಾವು ಕೋರಿರುವ ಮಾಹಿತಿ ಸಂಬಂಧಿಸಿದಂತೆ ಸರ್ಕಾರದ ಯಾವುದೇ ಅಧಿಸೂಚನೆಯ ಪ್ರತಿಯು ಈ ಕಚೇರಿಯಲ್ಲಿ ಲಭ್ಯವಿರುವುದಿಲ್ಲ. The activist asked for the government notification, and the registrar replied saying that they don't have any such notification. But still, sub-registrar officers are putting a sign and a seal on the DOD's bylaws, and their home buyers of the flat are considering this is a registered body. So very important RTI notification that everybody should understand. And in 2022, one of the activists has filed in RERA as well, saying that, can you please give us a gazette notification or a circular authorizing the sub-registrar to register apartment association society by laws which are annexed as part of the deed of declaration submitted as part of the Karnataka Apartment Ownership Act 1972. But the RERA replies saying that even the RERA also don't have any such circular from the government. Please remember, RERA is a regulatory authority which is controlling the real estate projects, supposed to control the real estate projects, supposed to control the cheating that is happening in Karnataka. They also responded to the query. You can make a note of it. It is very latest. 23/9/2022 is the response given by the real estate authority, saying that they also don't have any circular from the government where based on the deed of the declaration under Karnataka Apartment Ownership Act 1972, an association can be registered. So this is very, very important orders of the government that we are flashing on the record, saying that sub-registrar don't have any notification from the government. They don't have authority to register any association, and RERA is also confirming that. Very important. So on this matter, there is already a PAL which is being filed. I don't want to go into the PAL because the subject matter is in the sub judice of the High Court of Karnataka. With due respect to it, I just posted some of the important events that happened on this particular case. It's writ petition 511. I think our Sudhir Pillai sir and the eminent personalities will speak about this on what is the filing, why it is the filing has been done. But we will not pass any judgment of our own. We will not include any of our arguments on this. We will tell only the facts. We will tell only the facts about why the case has been filed, and we will tell the facts about what are the challenges that we are facing as a home buyer. Since the subject matter is in the court of law, we don't want to pass any, our personal judgment or personal that will derail the process. So that's one of the important aspects. There was a hearing happened on 28/9, and there is Mittal BR Learned Counsel for petitioner number 1 to 5. Mr. Pratima Honnappa Learned Additional Government Advocate for the State Respondent Issue Rule has been passed. So the case is still running. The writ petition 511 of 2021. Okay. So what is the problem statement? So everybody is thinking that, okay, we have an apartment, we have a a running association under different acts, right? Whether it is a KSRA Act, KOA Act, or it is a KCSA Act or Companies Act. What is the problem that we are trying to solve? What is the problem that Karnataka Home Buyers Association, Karnataka Home Buyers Forum has pointed out, which has been fighting across the industry, and a lot of other organizations also fighting for this? Three important problem statements that we want to bring onto the public domain. The first very important point is apartment project land title transfer not happening in Karnataka. Please make a note of this. Apartment project land title transfer not happening in Karnataka. Second one. So let me give brief about the first point. When I say the project land transfer, it is not about UDI mentioning in the sale deed. Please understand, your apartment is built on a land, whether it is a DC converted land or a Khata maintained by the BBMP, it doesn't matter. It is a land that is on which your apartment is being built. Is the land also transferred in the name of the association through a conveyance deed, or somebody claims that KOA or any other act can only sufficient? We want to see the names of the flat owners in the revenue records. Very, very important points. Ultimately, whichever acts as a home buyer, we are not bothered about it. What we want is landowner's name should be replaced. The builder name should be replaced with apartment owners, list of 100 or 200,000, or the name of the association, which is possible. That is the important ask from the Karnataka Home Buyers Forum. How to make it happen, whether it is technically possible, legally possible, is something that the government need to work out. A very, very important finding, Karnataka Home Buyers Forum has found out apartment project land title transfer not happening in Karnataka. Second one is, there is no registration status for apartment association to take conveyance deed, except cooperative societies. I want to make it a declaration. Cooperative society has got a registration status. KOA, we not seen single a registration certificate, single registration number throughout Karnataka. So this is one of the important disclosure that we wanted to make on this platform. We have not seen a registration status for apartment association to take conveyance deed. Third point is, there is no proper governing body from the government on apartment associations, except cooperative societies. So I wanted to make it number 2 and 3. The exception is for cooperative societies, but rest of the association, we don't have a governing body. We don't have a registration status. So very, very important stuff. 1, 2, 3. This is a problem statement we want to bring onto the table. After this, let us debate on this. What is the solution that exists? And I will hand over the mic to our Admiral Sudhir sir to walk us through some of the important technicalities and find out What is the solution our Sudhish sir, who is a researcher on this platform, found out, and then we'll walk through Subhatro as well. Handing over to you, Sudhir sir.
Can I say something? This is Amaya.
Yeah, please go ahead, Amaya sir.
Yeah. No need to say sir for me, just Amaya. Okay.
Oh, okay, yeah.
Yeah. So first things first. I urge people to raise a complaint with sub registrar in case they have doubts about the DOD registration. Please write to the sub registrar and observe sub registrar's silence on this. This makes it very, very clear that sub registrars may be facilitating incorrect registration of documents.
Point, sir. Very good point. So ultimately, what is required is home buyer's flat owner's name should come in the revenue records. So what is, how, who is doing what? We want to raise this alert to everyone saying that our names, our association name should reflect in the revenue record. That's a very good, very, very, very direct ask from the people of Karnataka to the government. And this platform, I wanted to put across a request to our Honorable Chief Minister, Cooperative Minister, Housing Minister, Revenue Minister, Finance Minister. All 5, 6 departments need to work together to find a solution to it. So yeah, with respect to that note, I will hand over the mic to Sudhir Pillai sir to walk us through the fundamentals of what the problems that we are facing and the solution to the problem statement that we are defined. 3 important problem statement. We don't want to get into the operational issues of the apartment association. Elections are not conducting. Once you have a governing body, everything will fall in place. So 3 important addressing. If you address this, the problem will be addressed. Please go ahead, Sudhir sir.
Okay, thank you, Dhananjay. Now, before I start off, let me make a few disclaimers. It's my pleasure to be on this panel to talk about certain issues that have been flagged, but I'm not an expert. I can't claim to be an expert. I'm a home buyer like you. Only thing is, I'm a retired person. I have a lot of time at my disposal. And having faced problems like you all face, we have decided to get into this subject in great detail. And so what I would share with you is my understanding of some of these issues. My presentation is a presentation I made a few weeks back to Jalvayu Vihar Apartment Owners Association. Sena Vihar was also present. And that meeting took place after the Air Force Naval Housing Board, which comes under the who's the promoter who created Jalvayu Vihar, wrote to the state government asking for how should the association be registered. And they got a reply from the IGR, which told them very clearly that they are required to register either as a cooperative society or a company. So on the basis of that letter that they received, they wrote to Jalvayu Vihar, telling Jalvayu Vihar that you need to progress along these lines with the aim of taking conveyance of the land title. So that is the context in which I was invited by Jalvayu Vihar. And the presentation that I show you today is largely to clarify there are a lot of differing views on the subject. So what I will do is, without being very judgmental, I will put across to you certain legal positions, legal terms, which you need to understand that will help you expand your understanding of the subject. So with that, I'm going to be sharing my screen with Dhananjay's permission, and I will then go on to it. Okay, I hope my screen is visible to all of you. Okay, there it comes up.
Yeah.
Okay, so my presentation is titled Ownership Flats. Notice I use the term flats and apartments separately, and its management. So that is the core title. As a subtitle, I have a primer on some legal terms for home buyers and owners. So we have the Karnataka Home Buyers Forum. Buying an apartment or even a plot or a unit is one part of the process. Then there is a transition to ownership, and how you buy, how this transition takes place is extremely important to ownership, and not just in your own lifetime, but in the lifetime of your heirs also. Okay, now please understand that a lot of the laws that have got enacted are largely concerned with ownership flats. You may well have a plot of land, you may set up a house on it, but the laws that exist are laws enacted to regulate the sale, transfer, and such a management transfer of ownership flats. Ownership flats involves the ownership of a part of a building. This is the second line. Involves ownership of a part of a building as opposed to the ownership of the whole. Please note this, the second bullet here. Involves ownership of a part of a building as opposed to the ownership of the whole. That is what ownership flats are all about. It is made possible by the construction of multi-unit building on a piece of land in which different persons can exercise ownership rights in individual units. So you and me are owners of our individual units. So there are laws which lay down how we can each exercise our ownership rights. That means that ownership right that is bestowed on us, how is it exercised? And one of the various reasons why these acts are there, one of them is to obviously avoid conflict with the developer and other owners of the flat in the same building. Peaceful and meaningful enjoyment of property is something you'll hear from everyone. But because of conflict, this peaceful and meaningful enjoyment doesn't take place. So our aim should be to understand and avoid this conflict. Now, I'm now flagging here the Maharashtra Apartment Ownership Flat 1963, MOFA. Now, this was a very significant legislation which came out of the state of Maharashtra. Now, Maharashtra and Bombay specifically, after independence, as you know, a lot of people moved there, especially from erstwhile Pakistan, Karachi, and a lot of people came down to Bombay. So there was a huge rise in the population of Bombay in a very small piece of land in the island of Bombay. And there was a problem there of residential housing. So those who had title over the land, they started exploiting these people who came in. They started selling ownership flats to get around certain problems with the Tenancy Act. To avoid the provisions of the Tenancy Act, they started selling apartments or flats. But those who had the title over the land transferred only possession of a building without passing on clear title of the land. Now, this line I'm pulling out from a book on RERA by Ramani Advocates, released by the state government when RERA came into force. So if you look at it, the genesis of MOFA and of COFA in Karnataka is to sort out this issue of land title. Mainly. And how did this come about? The government of Maharashtra appointed a paymaster committee. And it is this committee that drew up this bill, which became this act. Initially, it was enacted for 5 years. But after 5 years got over, they decided that this act will continue. And it continues till today. Even after RERA has come into force, MOFA still remains relevant. And if you notice the full form of the Maharashtra Ownership Flats Act and of the Karnataka Ownership Flats Act, it is to regulate the promotion of construction, sale, management, and transfer. Regulate whom? The promoter. So you need to understand this, because often you'll hear the term landowner, builder, developer. But remember, this act regulates the promoter. On one side, you have the promoter, and the other side, you have the allottee in RERA and a flat buyer in the case of MOFA and COFA. So basically, it regulates this transfer, this construction, sale, management, and transfer. Now, MOFA does not lay down or give legal status of a flat owner in relation to their flat. MOFA doesn't look at what is your relationship, ownership, legal status of your ownership of the flat, or also in relation to the organization formed by the flat buyers. Okay, MOFA just regulates the promoter. COFA just regulates the promoter. This relationship between the flat owner and his own flat, the flat owner and his association or organization is governed by the Maharashtra Cooperative Societies Act 1960 or the Companies Act 1970. And in the case of Maharashtra, in MOFA, you also have the Maharashtra Apartment Ownership Act 1970. However, in Karnataka, this relationship is governed by COFA, and COFA only lays down Karnataka Cooperative Societies Act 1959 and the Companies Act Today you have Companies Act 2013. So please understand this context. I'm trying to define the context of MOFA vis-a-vis KOA, RERA vis-a-vis KOA. Yeah. Okay. Now here is a Latin term. Now I don't want to confuse you. There's a lot of text here. Don't have to bother too much about the text. Don't even have to try and read it. All I'm trying to tell you is that when it comes to property laws, especially real estate related laws, it has its origins in ancient Roman law. And this is a Latin dictum, which actually is relevant till today. Now, this particular the line means that the superficies, that means whatever is built on a land, the superstructure on a land belongs to the owner of the soil. This is the basic dictum which governs property rights as far as land is concerned. That means if there is, the land is the basic datum, land is the primary ownership. Anything that's built on it actually belongs to the person whose land it is. Okay, now this particular dictum is what you find even in the Transfer of Property Act. So when you transfer a property as per the Transfer of Property Act, you are actually transferring the land title. And because of this old legal dictum, it is assumed that whatever sits on it, say there's a building on a plot of land, that building also gets transferred by transfer of the land title. That is where you'll find sale deeds will talk about bounded on the north by a road, east by so-and-so, south by so-and-so, west by so-and-so. So that is how transfer of property envisaged. In those days, there were no apartments, so to say. To get around this, because the land was a primary means of ownership, and anybody who had a building on a land, it was the landowner who assumed ownership of the whole building. To get around this, a special acts across the world, and in India, you had the Maharashtra Apartment Ownership Act first getting legislated in 1963. And we in Karnataka are beneficiaries of an act called the Karnataka Apartment Ownership Act 1972. The purpose of this act, the primary purpose of this act is not the regulation, the running of associations as many would like to claim, but it is about providing for ownership and heritage. Like I brought out earlier, a building is a larger whole. There's no floor of four, but it is this bridging special and that permits it. Now, what you must understand, and what I will hope is for other components framework, means apartment maybe the fourth or fifth floor, there is a need for an incorporated, and this necessitates an incorporated as
Sudhir sir, I think we lost you. You're on mute. Hello? Amaya, can you just check you're able to listen?
Okay, right. So can you see my presentation?
No, sir.
No.
Okay, 1 minute. Let me just share it again. Like some interruption took place. I don't know whether it's at my
some-
end or.
No idea, sir. Sorry.
Yeah, 1 minute.
Yeah.
Okay,
Yeah,
can you
now
see?
we are able to see. Yeah.
Okay, I'm sorry, you are seeing my presenter view.
Yeah.
Yeah, okay. I think you're seeing my presenter view. You see all my next slide also. Anyway,
Yeah,
for
we
the
are seeing-
time being, let's concentrate on this big slide, which is my main view.
Yeah.
Okay. Okay. And so you will realize that Mr. Dhananjay was using the term registered association. I'm using the term incorporated association. And this requirement for an incorporated association is defined by COFA and RERA as unavoidable. I will speak about this. Now, please understand that in India and in most of the Commonwealth and in the US, we follow what's called a common law system. And in Europe, where these Roman laws came from, you have a civil law system. Now, in the common law system, this has a history which goes back to English monarchy, which used to issue formal orders called writs when justice needed to be done. And because writs were not sufficient to cover all situations, courts of equity were established and devised so that appropriate remedies could be given based on equitable principles. Okay, I'm mentioning this because this is the system that's actually in practice in India, but increasingly a lot of number codification of various acts have taken place, like RERA, like COFA, and therefore we have ended up in some kind of a hybrid between common law and civil law systems. In the civil law system, codified statutes predominate. So you will see normally when you go to the court, it's a dialogue between the judge and the advocate, especially the senior advocates when it comes to places like the Supreme Court and High Court. So it is their expert knowledge which leads to justice. Now, this is a system which came from a time when there were not very many codified laws, but slowly more and more codified laws have come in, and therefore we have a hybrid system. So a lot of what you see, especially in places like RERA, the quasi-judicial body RERA, the appellate tribunal, is actually a takeoff from the common law system, where two people have a dialogue, the advocate and the people on the bench, and they take a view. You know, like I know Chairman RERA has been accused of not doing things properly, but he follows a system based on his superior knowledge and as explained to him by various advocates. So based on two advocates who explains it better, he may take a view. However, what he ignores is that there are codified laws which he needs to follow. So this is the point I want to make, because this difference is important to understand. The next word I'll go to is title versus ownership. Now, in property law, a title is a bundle of rights in a piece of property in which a party may own either legal interest or equitable interest. I'll explain what the legal interest or equitable interest is. What I would put across very simply is, in the case of our apartment complexes, the legal title continues to be vested with the promoter or the landowner whose name it originally was. The legal title isn't getting conveyed or mutated in favor of the owners association or in the name of all of us owners. What we have with our sale deed is an equitable title. So please understand these two terms. I spoke about how there was a system of equity in the common law system. So this comes from the common law system, an old system where some kind of a title was given. It was largely meant to protect the monarchy who owned most of the land. But in this day and age, you have laws which supersede all this, and the laws are being ignored, is what my case is. Now, title is conferred by formal documents such as a deed, and this deed serves as evidence of ownership. Now, we have a sale deed which gives us the title of our apartment, but there is no conveyance deed, a registered conveyance deed as required by COFA and by RERA as evidence of ownership of the land in the name of the association or in the name of all of those owners. Conveyance of the document may be required in order to transfer ownership of the property. So the registered conveyance deed is a requirement as per RERA. The title is distinct from possession, a right that often accompanies ownership, but is not necessarily sufficient to prove it. A person who has possession actually has an equitable title, but not the legal title. Now, in case your house is mortgaged, your apartment is mortgaged, the bank is actually holding what is called an equitable mortgage, and he has certain equitable title rights. And you don't even have equitable rights title if your bank is mortgaged. So you have a situation where promoters, builders often mortgage the common area land to a third party, and even the legal title gets mortgaged. So this is the situation we are faced with. In many cases, possession and title may each be transferred independently. For real property, land registration and recording to provide public notice of ownership is very, very important, and it is not being done in case of our common area land, is the case that Mr. Dhananjay so nicely brought out in his opening address. So this is legal title versus equitable title. I don't want you to go into this text. There's a lot of text. It will take up a lot of time also. But please understand, a legal title refers to the responsibilities and duties owner has in maintaining, using, and controlling a property. Equitable title is a beneficial interest. It gives the equitable title holder the right to acquire the legal property, but he is not yet acquired. So when you have a sale agreement, you hold an equitable title to the property from the date of purchase and sale agreement execution. And that is why these days it is compulsory to register your sale agreement, so that in courts of law, it can be properly looked at. The legal title is not transferred until the deed to the property is transferred from the seller to the purchaser. In the case of apartment units, it is not just about transferring the legal title of the individual apartment. There is a dual requirement, a dual conveyancing involved, where the legal title of the common area must also get transferred to the apartment association. This is clearly spelled out both in COFA, where the promoters are regulated, and in RERA. This is a mandatory requirement by those two regulatory special acts. Please understand this. Now, the person with the legal title, he has various rights which are spelled out here. One of them I flagged is development right. So what do our builders do? They retain legal title, and it is as if you have equitable title. You do what you want. You have easement rights and whatnot, but development rights are with me. I'll continue to develop in this property. If FAR increases, and if I can create a 60-story building, say in 10 years' time, he will create the 60-story building and we have no rights, which is not correct as per law. So this is where the whole discussion is actually focused on. And this is a slide which was originally prepared by Ameya. I borrow it. But essentially, like Mr. Dhananjay brought out, so you have 3 acts enacted in Karnataka: COFA, KOA, and KSRA is also used, like he mentioned. And then you now have a parliamentary enactment, RERA. What you must know is, with the coming into force of RERA, if there's a contradiction between a state act, then the parliamentary act will prevail. For example, I'll show you a lot of definitions, and there'll be differing definitions. So which definition the correct definition? If RERA is relevant, then the RERA definition will prevail over the state. There can be no contradiction, is what the Constitution says. So like I brought out earlier, how COFA RERA regulates all these aspects. COFA RERA is aimed to protect buyers from malified tactics of promoter, such as change of building plans, non-transfer of corpus, non-registered owners association, etc. COFA RERA provides for fine and imprisonment for promoter or its estate manager, whereas in KOA, there is no such penalties laid down in that act. All you can do is you're supposed to go to the competent authority, the registrar of cooperative societies, and when you go to him, what does he tell you? He tells you he has no jurisdiction, like Mr. Dhananjay brought out. So where are we headed? KOA, like I said, it enables inheritance of apartment with an undivided interest. I will speak about undivided interest. KOA is an elective, not a statutory mandate like COFA. However, there is a slight amplification I want to give to something Mr. Dhananjay said in his opening remarks. He said that in quoting the NCDRC, he stated that various people have the rights to come and complain in the consumer forum. And in the list of people who could come and complain there, he included the Association of Flat or Plot Buyers. But please know, in Shobha Hibiscus versus Shobha Limited, the Supreme Court has stated that an association registered under the Karnataka Apartment Owners Act is not a consumer in the meaning of the Consumer Protection Act, and therefore cannot. So you could not go to the registrar to seek redressal. Now the Supreme Court has said you can't even go to a consumer court. So what is the option left? Go to a civil court and spend 15 years there. This is the situation we are faced up, which we need to sort out. KSRA, like I said, it's very clear. It is meant for welfare and education, sports libraries, and cannot be used for maintenance. And there are good reasons in law why it cannot be used. Now, this is a screen grab. I don't know whether this text is visible to you. Based on the kind of device you are on, it may be visible, may not be visible. But the Bangalore Apartments Federation, on one stage, they attended an international seminar which was held here by and some international organization of community managers. And they were very gracious enough to invite me also. So those days I was engaging in a dialogue with Bangalore Apartment Federation. So they asked me also to attend this international seminar in the JW Marriott, which I did. And if you see here, the definition of a community association is flagged by this international body. And most of the people attending here are builders, and there were a few home buyers like us there. Bangalore Apartment Federation also was represented to an extent. So what he says is a community association is a non-profit, legally incorporated entity for a group of property owners living in a community, sharing costs, etc., etc. But notice this bold text, legally incorporated entity. The word is not being used to register. Now, what is legal incorporation? Now, an association, as per the Collins Dictionary of Law, is any group of people who have joined together for a particular purpose ranging from social to business. Okay. Now, an association is not a legally established corporation or a partnership. To make this distinction, the term unincorporated association is often used, although technically redundant. If you look at RERA, one of the people who can go and complain to RERA, even an unincorporated association can go. So the correct term to be used, as put out here in this previous slide, is is incorporated entity. So that brings you to the next definition, which is a body corporate. It is by creating a body corporate that your association becomes an incorporated entity. Now, generally the term body corporate or corporate means an association of persons having the following characteristics. And this is a definition in law, and it is also endorsed by a lot of Supreme Court judgments on the subject. One, it is incorporated under any law for the time being in force. So the incorporation is based on a certain law. Which are those laws? In our context, it is only the cooperative society and the company. I'll tell you why. So just registration, plain vanilla registration, like happens in the case of KSRA 60, is not incorporation. For it to be incorporated, that act under which you register an association must make you a body corporate. I'll show you how. Okay, there are various other features given here. And what is very important is it has a capacity to sue and be sued. Can an unregistered apartment owners association sue or be sued? In law, no. And most important is the red one, can have property in its own name. If conveyance of the common area property is to be taken by the association, then you have to be incorporated. Otherwise, you cannot have property in your own name. And this is why promoters, builders, land developers are in such a hurry earlier to register you as KSRA 60, or now after KSRA 60 got banned, they want to register you as KOA, because in both those schemes, you're not becoming an incorporated body. And as long as you're not incorporated, land conveyance cannot take place, even though the land law requires it. So they glibly sit saying the association cannot be conveyed. So I'll hold it in my name. This is the issue we face here. Now, as far as societies under KSRA 60 is concerned,
I request everyone to hold on for questions once Sudhir sir completes the session.
Yeah. Once, if you look at KSRA 60 association, this is a Supreme Court judgment I quote. the Supreme Court of India delivered at length whether the nature of a society as created by KSRA 60 is that of a corporation. Is it incorporated? Does it create a body corporate? The court, while interpreting the provision, held that a society is not a body corporate. Okay, so it is registered, but is registered for various other purposes. It is not a body corporate that can be used. So this is the legal basis to some of what has happened in recent time from the registrar's office and even the VDB Celadon case. Now look at this here. I'm just flagging a few definitions. Now in COFA, flat includes various things. Separate and self-contained premises. It includes residence, office, showroom, shop, godown, includes a garage. This is the verbatim definition of a flat given in COFA. Now in RERA, you look at the definition of apartment. It borrows largely from the definition of flat, and RERA today has given a larger context to apartment and includes all kinds of spaces, includes residential or commercial use. So an apartment can be residential or commercial use, such as residence, office, shop, showroom, godown. Everything is included in RERA. Okay, so please understand the difference. Now, when you come to KOA, this text is very small. Apartment is defined. Here it means intended to be used for residential purposes only. So therefore, if a DOD is legally registered and a submission takes place to the Provision of Apartment Owners Act, technically it can apply only to residential purposes. And one more thing I want to flag is, an owner is defined in KOA. Who's that owner? It is the apartment owner. We are not talking about the landowner who claims a right to go and register a DOD. If anybody can register a DOD, it are the apartment owners acting collectively. And why do I say so? Not because I have a view in this matter. COFA says so. Please look at COFA. This will be explained in that. Okay. And one other definition is undivided interest. This word repeatedly finds a place in KOA. You will not find undivided share even once mentioned in any of these acts. RERA, I think, talks about undivided share, but you see, it is not defined. An undivided interest means that two or more persons have an interest in a property held under the same title. Remember the definition of title I told you. That means if a property is held under one single title and there are two or more persons who have an interest, equitable interest, then that is the interest that is spoken about. The undivided interest encompasses whole property and its holders have equal rights to entire property, equal rights. The undivided interest is not separated into parts or shares. Thus, no individual owner has exclusive rights to any specific portion of the property. So we have an undivided interest in our larger property. This concept of undivided share, especially it masquerading as conveyance of land, has no basis in law. The Karnataka Municipalities Model Building Bylaws 2017, which has come about recently. You had earlier the Bangalore Building Bylaws of 2003. So you have a recent enactment called the Karnataka Municipalities, which applies to all the municipalities, not just the Bangalore, not just to KMC. Here an owner is defined. Owner means a person who for the time being is receiving or entitled to receive, whether on his own account or as agent, the rent or profit of the property. And in whose name the approval for development is issued. So in this particular case, in the KMC bylaws, it is specific to development, it's specific to a promoter. So as long as the promoter is involved in development and he's got approval, he's an owner in that limited context. Now, this is a very important context. There are a lot of responsibilities like under Environment Act, etc. The Water Act, Air Act, Electricity Act is fixed on the owner. Now here there are a lot many more definitions, very small print, intentionally small, because I don't want you to read it because it will take a lot of time. But please understand the Bangalore Building Bylaws of 2003, which is since now you have the Building Bylaws of 2017. Various definitions are giving. Building, what is a building? What is an apartment? What's a group housing? What is high-rise building? What is a residential building? What is row housing? And in the latest enactment, you have the same things with slightly different definition, and you need to look at these definitions very carefully, because some of these definitions, let me tell you, are not in our benefit. It is the benefit of the promoter. So we need to look at all these and maybe even challenge it someday. High-rise building, where you need a fire clearance, apartment building. So this all has relevance when it comes to law. Now, when you talk about the Transfer of Property Act, it is in India, you can transfer parts of a property. It's not allowed in England, where the original act came from. But please understand, an apartment or a flat in a building is not separate from the building. I am quoting from again that Ramani Advocate's book. It is recognized as a separate property only in the flat ownership system. That means if your property is submitted to the provisions of the Apartment Ownership Act, then you become part of the flat ownership system. Only then your apartment or flat has an independent status. In a cooperative society, especially a co-ownership property cooperative society, ownership of that apartment is also with the cooperative society and not with the individual. So please understand the line. Apartment or flat is not separate from building, is recognized as separate property only in the flat ownership system. Again, promoter. Okay, I told you about how the builder, earlier the promoter in COFA was a person who constructs or causes to be constructed flats or apartments for purpose of selling them, some or all to other person. He is a promoter. Now, RERA has expanded this and included various other people, included development authority, included the landowner, included state level cooperative housing finance. It includes everybody. And if there are 2-3 people involved, then they are jointly responsible. They are all promoters. So if there is a joint development, not only is the developer a promoter, even the landowner is a promoter, and responsibilities are cast on him. He is required to follow it. So promoter shall be responsible for all obligations. And here is this responsibility fixed between promoter and the association allottees. And till when is he responsible? Till the conveyance of all the apartments, plots of building to the allottees. That means to the individual apartments to the allottees, and the common areas to the association allottees is done. So till this is completed, the promoter remains responsible and under the provisions of the RERA and COFA. So you have in CRP 96 a High Court judgment which says that once the association DOD is registered, then the promoter has no role, COFA has no role. That is what CRP 96 says. But if you ask me, this is what RERA says. Here is what a parliamentary enactment is saying vis-a-vis a state enactment, which is COFA. So these are all very subjective issues which we have to go and get clarified, and it will get clarified in due course. Now, COFA and RERA, if you compare them, they are very similar, right? Actually RERA has come from MOFA, and there was also something called the Maharashtra Housing Regulation and Development Act. So there are a lot of similarities between COFA and RERA with the slight changes. So if there is a contradiction, RERA prevails. Otherwise, RERA allows COFA to continue to remain in force. I will not walk you through each of these. This presentation will be available to you all. Please take a look at it separately. Promoter to enable formation of legally incorporated association. Please notice I don't use the word promoter to register association. Okay, I won't go into these laws. Promoter shall, under the laws applicable. Which are the laws applicable in Karnataka? COFA. And section 10 says promoter will take steps of formation of cooperative society or a company. Both create incorporated bodies. Promoter to convey title and execute documents. Convey title. Legal title has to be conveyed by the promoter. And then you also have the COFA rules. Here in Rule 9, where actually it is about the period for submission. Within 4 months, you're supposed to create the cooperative society or the company. But here there's a provision in the rule which says where the apartment takers propose to submit, not the promoter, not the developer, not the builder, where the apartment takers propose to submit the apartment to the provision of KOA 72, by executing declaration, then the promoter shall inform the registrar as defined in KCSA 59 and shall execute such declaration and deeds of. So if your promoter hasn't done this, in my view, he is in violation of section 10 of COFA, and there's a punishment and penalty laid down for him not doing it. This is what should have got invoked instead of, associations now trying to register DOD on their own. So here is a slide I used long back in a certain seminar, but there's a chronological flow here, which is given in COFA. First is you have to register an agreement. Then that agreement must specify what kind of an organization will be created, to which title is to be passed, not organizing to which administration will be passed. COFA says in section 3(2) within bracket H, the agreement must state in writing the precise nature of the organization of persons to be constituted, to which title is to be passed. Please understand why I labored on the definition of title. And then he says, you have to form either a cooperative society or a company. Why? Creating an incorporated body. Why an incorporated body? So that this title can be transferred. If you do not create an incorporated body, no title transfer can take place. And accordingly, you have to register cooperative society. And in case after the registration is done, after all the apartments have got sold, where the apartment takers propose, as soon as possible after the date on which all apartment owners being not have executed declaration deed. After all the apartment owners have executed deed of declaration, there's an option to actually migrate to KOA. But remember, by this time, your common area title should have got transferred to the incorporated body, but that's not being done. Common area is defined both in RERA and in COFA. I will not go on it. This is just to say that your land, among various other movables, are all part of common areas, and the land title has to be conveyed. So to close a long presentation, all I want to say is, in my view, this is my view, what is the way ahead? I think ideally, firstly, you must register an incorporated association or society in whose name the common area title can be conveyed. And what are these associations? Cooperative society or a company. Now, once this title is transferred, one could opt either to function under the cooperative principles or maybe even go on to the condominium principles, the apartment principles, with legal title held in the name of CHS. This is my view. There are a lot of steps here which have to be taken. Register cooperative society. The bylaws have to get ratified by the builders of the cooperative society or the incorporated association. There is a necessity to figure out how the stamp duty will be sorted out in this case. There is a requirement for a deemed conveyance, because most of these promoters are not going to agree to convey title. So a deemed conveyance is what permits you to go and get it done unilaterally. Sign and register an indenture or deed of conveyance on promoter to CHS, to the Cooperative Housing Society. The apartment owner bylaws be amended. The existing apartment owners bylaws or even a KSRA 60 association bylaws be amended to conform to bylaws of the Cooperative Housing Society. This includes issue of shares, and shares of CHS being a prerequisite for membership of the Apartment Owners Association. In my DOD, one of the prerequisites for membership of Shobha City Apartment Owners Association is you have to have 10 shares. Shares of what? Not just shares created on a piece of paper like Morishka Park has done, but shares incorporated properly through the oversight and processes of the registrar of cooperative societies. Okay, so with this, I will stop what I have to say. I know I've taken a long time. One of the things which I have not been able to very clearly bring out is that as far as the cooperative society and the Companies Act is concerned, I have a slide here. I don't know why it's not come up. Probably it's got hidden. In those two acts, it is laid down clearly that registration as a cooperative society will create a body corporate with features, those 5 features that I mentioned. Same thing is there, same para applies in the case of even the Companies Act. It says registration as an incorporated company will cause this body to be a body corporate and will have right to sue, be sued, common seal, transfer a whole land in its own name, etc., etc. So, and there are Supreme Court judgment says that if an incorporated body is to be created, it should be based on that statute so providing for it, not because somebody feels like some department of Karnataka government saying, "Chalo association ko bhi incorporated kar do." ऐसे नहीं होता. It is laid down very clearly. There's a legal requirement here because it has a lot of connectivities to the Contracts Act. Your agreement is a contract. Remember, land, state subject, contract is in the concurrent list. That is why RERA is relevant. So since there are such linkages involved, Karnataka has no choice but to make the proper thing happen. There's a High Court hearing not only going on in our High Court, there's a High Court hearing like this going across the state, one being in Orissa. And interestingly, the Supreme Court is monitoring that each state ensures that RERA is not diluted. And they have actually asked for their model agreement because it is that agreement, that contract, which is the start of everything. If the contract is written in a faltu manner, you will get a faltu delivery. With this, I will stop and thank you for your patience.
Thanks a lot. Thanks a lot, Sudhir sir. And with this note, once again, I wanted to, open up this platform for any question and answer. We also have, Subrato also part of the discussion. Zamaya is also part of the discussion, and Commander Sudendra I can see, and a lot of other activists I can see RTA activists also on the panel. A lot of people who are interested in this subject called apartment association and land transfer, and a lot of issues that we are facing as a home buyer in Karnataka. I think it's a very good development that we are seeing in this platform, and then we want to see that, okay, this has been publicly discussed, publicly debated topic, because lakhs and lakhs of home buyers are already getting impacted. And then we don't want to see the repetition of what happened after somebody gets their house is out of the house, and then somebody throws you out of the house saying that I have a land rights, and then you don't have any legal rights.
Dhananjay, can I just interrupt?
Yeah, please go ahead, sir.
Just permit me to just flash this one slide.
Yeah,
I somehow didn't focus on too much.
Okay.
It was there among my slides, but just to
go ahead.
See, if you see this. Here you see the body corporate is defined under the Karnataka Societies, Cooperative Societies Act 1959 and the Companies Act 2013. It is this section, this particular insertion in these two acts that renders it a body corporate. Cooperative societies to be body corporate. Date of incorporation, basically here he says that from the date of incorporation mentioned in the certificate of incorporation, such subscribers to the memorandum shall be a company, a Section 8 company will also be a body corporate. Here also they'll be and with powers to hold property, enter into contracts, institute and defend suits and other legal proceedings. Similarly, in the Companies Act. What I want to tell you is the associations as created today, even if registered, is actually, in my understanding, not competent to contract under the Contracts Act. And if you're not competent to contract, what is the worth of your contracts you get into with your service provider, with your security firm, your lift firm, your STP maintainer? It has no legal basis. And I have seen an occasion in my complex where Iron Exchange, a reputed builder who was given contract for our STP, he walked out after our whole STP went underwater and nothing could be done to make him accountable or responsible. Why? Because you entered into a paper contract which has no meaning. So today you are faced with situations like your building may get demolished because it is on an encroached lake, and you have no competence to contract anybody. You can't even contract a lawyer, can't even contract an auditor technically. And all these procedures followed in Karnataka, in my view, have no basis in law. And I think it is very important for our own protection. We must be legally compliant. Thank you.
Thanks a lot, sir. I think it's very important. Incorporated body is what is required under Cooperative Societies Act or Companies Act. This is a strong message from Sudhir Pillai side. Now the platform is open for all participants who are on the Zoom call, and we are observing the questions that's come up. Probably Ameya, you can also come online and post some of the questions. And those who want to ask questions, our request from the platform, this is an open platform. We want to see your faces. Request everyone to put your video on now, because the now is the important debate and discussions. An open platform for questions to be asked for the experts in the Karnataka Home Buyers Forum. And please go ahead and ask questions. We have a lot of experts on the call. So please put on your video, because we want to see you who is asking the questions. We'll move into the gallery mode also. Yeah.
Dhananjay,
Yes, sir.
I would
Please
like
go
to
ahead, sir.
add, I would like to add to whatever Sudhir has been going on talking about legalities.
Yeah.
The basic thing that we need to do is, there are a lot of anomalies, and the people who are making this happen are the builders, the ministers, and the government bodies. They are all fed by the builders. And we, the homeowners who struggle all our life, pay the taxes, pay for everything, we are made to run pillar to post, go into courts and things like that. So
Right.
unless we come together,
Yeah,
and try and address all these issues,
exactly.
it's not going to be solved.
Exactly.
That's all I wanted to say to everybody who's attending. If there are anything that we all can do, is to come
Yeah.
together and sort out
Exactly.
issues.
Exactly. Excellent
That's
points.
all.
Yeah, excellent point, Subrata, that you brought up. It's a collective efforts. It's a collective effort that need to be done. I know a lot of organization, apartment federations, Bangalore Apartment Federation is working on, the collective efforts team is working on. A lot of home buyers associations are working on. A lot of people have filed PAL also in the court of law. What is important is, to make the law straight, to make the law which is going to help the home buyers is what the final intention. And it's very important that we work collectively when we make it as a public interest litigations, or when we are working as a public cause. It's not about the individuals. It's not about the individual benefits. It's all about the society benefits. With that note, I think Romil has a question. Please go ahead, sir.
Yeah, my question is, since RERA prevails over any other act in place where there is a difference in implication, what is the possibility of agitating a court or a body other than RERA or KRERA in our case for seeking compliance with the provisions of RERA?
Can I answer?
Yeah, please go ahead, sir.
Mr. Kulshest, one of the persons I learned a lot from, who unfortunately is not with us anymore because of COVID, is Mr. Ajit Naik, who many of you may be familiar with. Right. He has drafted a public interest litigation, which is extensive. It's an extensive public interest litigation, which looked at this very subject that you very correctly flagged. That is, all the incongruities in the Karnataka Acts vis-a-vis the RERA Act, he's put together in a draft public interest litigation, which unfortunately he couldn't file because of COVID, and then he passed away during COVID. But there is a need to take this to invoke the writ jurisdiction of the High Court and get this clarified. In the interim, what people must do is, while everybody quotes the Karnataka laws, for example, when you talk about completion certificate, it suits the builder that he uses a completion certificate as provided for in the KMC Act. But in a court of law, a good lawyer should be able to argue that we are not talking about a completion certificate in the KMC Act. We are talking about a completion certificate in RERA. We are talking about OC in RERA. An OC where water, electricity, sanitary services is inbuilt into it. There can be no OC without water, electricity, and sanitary services. That is what RERA says. So you're very right. The need to take it to court and get this sorted out.
Yes.
Yeah, I think, sir, I wanted to add one more important point. Recently, I have seen a notice issued by the CGI, which is lift approving authority, Department of Electrical Inspectorate, to one of the builders in a project called Shobha Arena, where 10 lifts are being running without the lift approval, and a notice has been issued to them, and probably they may be working on that. But those buildings have got a provisional OC, and those buildings have been running. There are 400 to 500 families are living there. So without the approval from the departments, people having the POC or partial OC, and then people are risking their life. So probably, Romil sir,
Yeah. Another question I have is that the builders who promote a project supposedly under KAOA, the documentation in terms of the sale deed and also other things they file with the KRERA, they may or may not show that a good 15% additional amounts are levied in the name of other charges. And these include things like electricity, water, genset, gas, and so on. One point is that these add-ons, they constitute up to 15%, if not more, of what is termed by the builders as the agreement value. Now, with regard to delivery against these so-called other items, where does RERA or any other legislation is getting attracted?
So Sudhir sir, you want to address this question? You are on mute. You are on mute, Sudhir sir.
Okay, there are various cases, especially in the appellate tribunal and even in RERA, where this particular subject has been looked at, has been invoked by people. For example, in my own case, there is the issue about providing municipal water. Yes, there is no Kaveri water, but the contract involves him delivering municipal water. So a lot of these issues are there with RERA. Some of the orders coming out on RERA on the subject passes the responsibility from the promoter to the association. My contract is with the promoter. It is not with the association. My agreement, you use the word agreement. So I think there's a case for the agreement terms to be enforced. Earlier, you had no choice but to go to the lower court. But today you can go to RERA and agitate the fact of non-delivery of essential services, which is a very vital ingredient of RERA. You cannot get an OC without all these ingredients being in place. So this is one gray area. And the only way to sort out these gray areas is by agitating RERA, the appellate tribunal, and if necessary, the High Court. And what I would like to inform you is that just yesterday, I think on the 8th, day before yesterday, the Supreme Court has more or less concluded a hearing in a certain project here. And it is expected that each of these judgments that come out, you had the DLF case of Wing Commander Arifur Rahman, you have the New Tech judgment, various judgments, and now once this also comes out, these laws are slowly but surely getting clarified. We have to be a little patient because the system is pretty entrenched, and to defeat it, you need the legal basis. Yeah.
In the interest of time, probably we'll have some other questions from others also. Kulukshetra sir, if it is okay with you. Yeah, go ahead.
So I have a question to ask both for Dhananjay and as well as Sudhir.
Yeah, may I know your name, sir?
My name is Gopalakrishnan Narayanan.
Gopalakrishnan. Go ahead, sir.
So the issue is, under Society Act, I cannot register an association now because they don't allow to register that. To become a corporate body, the only option left to me to go under Companies Act 2013. Companies Act 2013, the requirements are very large. I have to make it a public or a private limited company. I have to create the directors. I have to create a private company, memorandum of association, article of association, plethora of documents I have to prepare. I don't think that any apartment association will be willing to take up that laborious job unless they have enough resources and people to commit to that resources. Under the circumstances, right now, apartment association have got no option other than to form an association under KAOA 1972. I agree it is not a corporate body, but how do we go about it?
So I will answer that before we our experts Sudhir will jump in. First thing we need to understand is we want to protect our interest. See, if we want to protect our interest, we have to put our efforts. If we are not ready to put our interest, definitely this will continue. The system will loot us if you are ready to getting looted. The system will loot us.
I am not questioning the way forward. The way forward, yes. But right now, there are hundreds of apartments around Bangalore. You know that pretty well. All of them under 1972 Act only. But they are all functioning. For example, I live in an apartment which is 22 years old, registered under KAOA. Not even registered in the DOD and other vagera. I have filed a couple of suits. I have filed a suit against BBMP. I have filed a suit against the builder. All these courts are going on various courts, High Court, Magistrate Court, everywhere it is there. I cannot go to.
So I understand your concern. So especially people at senior citizens will have these issues saying that how can we fight, right? So first thing we need to understand that apartment is an asset, right? Whatever, it's not a small money, it is over 70-80 lakhs, or some people have invested crores of rupees to create an asset. For whose purpose? For us to live, your kids to live. For example, who want to make a property, right? You want the property to be passed on from you to your next generation, from that next generation to the next generation. So the problem we are trying to address is if you don't have an incorporated body, if you don't have a competent authority to look into this, you will have a chance of losing the land itself. You will have a chance of losing your rights. So if you are investing 80 lakhs today, and tomorrow your kid and your next pota or poti don't have the asset, and they have to run behind the courts of law to fight, is this something that we want to give it back to our next generation? Is something we need to think very methodologically and ensure that if we do this, tomorrow our generation will be fine. That's one of the reasons why Karnataka Home Buyers Forum is being formed, to ensure that we don't pass our liabilities to our next generation. We don't pass on our court cases to our next generation. Whether it happens because of somebody's will or whatever system corrections, that's a different story. But let us, all of us, put effort today to make a better future for tomorrow, right? If we say that, okay, it's running now, yeah, operation-wise it will run because nobody is bothered about it, right? If you're not bothered about it, then obviously things will continue as usual. But if you want to bring in change to ensure you have a right, you have to put effort. Nobody else will put an effort. For example, this is one of the important questions that I always ask and advise everyone, apartment association, saying that Karnataka Home Buyers Forum can take every burden and every association and then ensure that we get a justice. The answer is no. Karnataka Home Buyers Forum will facilitate. Karnataka Home Buyer experts will help you in terms of giving you the knowledge. And who has to implement in your project? It is yourself. You have to contact the right advocates. You have to get the documents sorted out. You have to ensure that whatever the legal law of the system need to be followed, you have to do it. It is the intrinsic urge. It is the intrinsic property that you own. It is not somebody else own. So if you want to protect our property, we have to put effort. We don't have a choice. If you want to live like this and pass on to our next generation, I will just, I don't want to comment on it because everybody has got their own.
No, but can I, Mr. Dhananjay, if I may
please go ahead, sir.
Yeah. Mr. Gopalakrishnan Narayan, I want to give you some specific examples, okay, of Bangalore. I was deputed by Bangalore Apartments Federation to Raheja Residency in Koramangala. Their case has gone to the Supreme Court, and the case involves their erstwhile developer, Raheja, selling the common area properties. And they have not been able to defend it. They lost it in the Karnataka High Court because they are not properly incorporated. They have a KSRA 60 association, one for each block. They have some 7-8 blocks there. They're not been able to defend it because they're not properly incorporated. That's one. Second is, in Gurgaon, there's a property called heritage city. The owners in those flats suddenly realized that the gardens around the building has been sold to recover money from the Chandra brothers who are in jail. Why? Because the title of that common area land was with Chandra brothers. I can give you many such examples. This Jalvayu Vihar that I spoke of, there is somebody who's come up claiming rights to that land. So what I'm getting at is by creating an incorporated body, you are securing the title of your land, which is very important. That's one. Secondly, you said it is very difficult to do it under the Companies Act. I would say under the Section 8 Companies Act, there is a way to do it of a non-profit company. However, if you say it is so difficult and nobody would want to do it, the procedure under the Cooperative Societies Act is already being followed through by various housing associations.
Yeah, that is easier.
No, not only that, people are doing it. It's already started. The process has started. I can tell you of 2, 3. There is a senior citizens community called Serene Urbana, Ozone Urbana. They have moved RERA and they are protecting the rights. One of the reasons why they believe their rights must be protected is the average age there is 80. The prime person who was driving that case, Mr. Sarat Chandran, passed away. But it is for the benefit of his future generations that he is invoking it. My submission to you would be, Karnataka Association is not registered. You can claim it to be registered. It is not registered. It is not competent to contract. It technically cannot sue or be sued. You cannot go to the consumer protection. I can give you so many. Yes, it caters for certain aspects, which is ownership of an apartment. But beyond that, the legal protections that you need require you to do what is not being done. The law requires you to do it. I'm not thought this up to tell you to protect it. So my humble submission.
No, I understand. Incorporated body, no, definitely better. But the issue is, as an association, can we approach RERA for redressal from the builder?
Yes. In the case, so let me tell you about RERA. RERA is a beneficial legislation enacted to benefit a certain class of people. And who are that class of people? Us, the home buyers. So that, like the Consumer Protection Act, which protects the consumer, here it protects the home buyer. And the provisions of RERA is such that every difficulty we normally encounter in a court has been set aside so that we are facilitated. The Civil Procedure Code has been set aside. The Evidence Act has been set aside. There are a lot of such protections within RERA, which makes it easy for you to go to RERA. Now, one of the things RERA permits is your association, incorporated or unincorporated, also has a right to go and complain in RERA. This is a provision. If this provision wasn't there, you know what the builder would have said? You have no jurisdiction to hear him, like Registrar of Cooperative Societies told Jalvayu here. Your jurisdiction exists. However, when you go to the higher courts, some of these laws can run into each other, but it will get clarified. Thank you.
Yeah. Any other questions?
Dhananjay,
Go ahead. Yeah, go ahead.
Can I answer Mr. Gopal Krishna, right?
Yeah, go ahead.
Yeah.
Sir, your question is very relevant. And I am one of those home buyers who have also been going through this process of Karnataka Apartment Ownership Act Association for almost 30 years. And my colleagues Sudhir and Dhananjay have already shown to you that my association has been running smoothly, as what you call, right? Contracting with various service providers, having court cases of different nature, and going through. All this has been happening for last 25 years. And let me tell you one thing, courts are not going to go beyond what you ask for, right? Nobody in the last 25 years, whichever cases which were fought between the association and somebody else or vice versa, have questioned the legality of the association. So court is not going to look at it, right? I had a problem with the association with regards to their management, with regards to their financial management, and a couple of other things. So I approached the competent authority as mentioned in the Karnataka Apartment Ownership Act 1972. And there you are, Dhananjay put across that small part of the order, though without saying that who and what they did. The competent authority, that is the Registrar of Cooperative Societies, dismissed the case saying that he has no jurisdiction in this case. So tell me, right, if your association is indulging in financial impropriety or any other such act, where will you go? Like what my colleague Sudhir Pillai told you, that if you go to the court, it will take you 15 years. Right? That is the reason. That is the reason. Yes, because as you, I'm sure, understand that a large number of home buyers seem to be satisfied with the situation of what it is. It is a chalta hai attitude of my country. Right? As long as they don't question associations, whether incorporated, not incorporated, registered, not registered, will continue to go on. If you are satisfied with that kind of a situation, please be so. Right?
One more
That is
point
all.
I want to make, which I made to Jalvayu VR Association, Apartment Owners Association. The average age of that association and a committee which met up with me was about 70, 75 years old. So, and their complex is 30 years old. And it is average life of complexes under the Indian Standards Act is 50 years. So I would say in about 15 to 20 years, this project, Jalvayu VR, is going to be a candidate for redevelopment. And when that redevelopment takes place, today it's a 2-story row house kind of a scenario. Tomorrow, when that land is now very, very precious, when that redevelopment takes place, in the same property where you have an undivided interest of say X%, you'll be able to create a 60-story building. And who gets the share of the 60-story building? In their case, the promoter is the Air Force Naval Housing Body. He may not take away your share, but our private builders will take that share away, denying you your investment in a property. Remember, in an equitable interest definition I showed you, all accruals that happen to a property, even if you have equitable title, you have a right to that accrual, not only the legal title holder. So please protect your property. It is for your heirs, for the next generation, that when they redevelop your complex, at that time, instead of it being say 100 apartments, you will be able to create maybe 300 apartments. Who should get those additional apartments? Yes, maybe a share might go to the developer. But otherwise, you should end up with from 1 flat about 4 flats. This is my humble submission.
Yeah, go
I
ahead.
would like to comment there, Dhananjay.
Yeah, go ahead, sir.
Yeah, so first things first, I think this has been really good so far. And one more thing to kind of note is that in the case of classic, I think the project where Jibin Jairam is there. So in the classic enterprises project there, it is unusual to see a builder fighting for enforcement of KAOA 1972. This is the first time I am coming across when the court has ruled very clearly that it has to be a cooperative society, and they have ruled it rightly there.
Correct.
In all other cases, nobody questions about KOA because people are just unaware of it. Exactly. So please be aware of what the right things are. It's a simple reading that one needs to do and understand what is right and what is wrong.
Yeah. I think very good submission, Amaya, that you made. Not only classic, even another project by name Mantri Serenity in Kanakpura Road. There was a RERA case that has been filed by the home buyers, and the RERA chairman has given a verdict to form Allottees Association under Cooperative Societies Act only. But still today, the order has come 7-8 months. The RERA order has not been respected by the builder. So this is, I wanted to submission that apartment associations are moving towards the cooperative societies because home buyers are getting awareness, flat owners are getting awareness. So the RERA is giving order to form cooperative societies, but why builder is not implementing? This is a question that everybody has to raise in your minds. Why they don't want to implement? So you will get the answer. Yeah.
Mr. Dhananjay, 1 minute. If there is this question that has been asked by Chitra G in the meeting chat.
Yeah.
I'll just answer that question because it will also connect up to what you just said.
Yeah.
So the question is, do we have any update on the total environment case in the Supreme Court? Yeah. Like I mentioned, on the 8th, there was a hearing of this particular case. And an interesting development is the Supreme Court actually acknowledged and it's a two bench, Justice Gawai and Justice Nagaratna, who was earlier in the Karnataka High Court. They have observed, the Supreme Court has observed that various recovery orders from promoters are paper orders, very difficult to implement. So in this particular case, when the builder accepted, he said, delay compensation of 1.5 crores is my reading that I must pay him, whereas the other side had a much larger figure in mind. The Supreme Court has told the promoter, deposit this 1.5 crores in this court, because if I just pass an order saying you are entitled to delay compensation, then he'll run around trying to get it executed for the rest of his life. So the court is now taking a deposit.
Yeah.
And there's a similar provision in the appellate tribunal to take a deposit.
Excellent.
But we need to fight for this and get those deposits from the court rather than go to the DC and whoever else.
Excellent. I think there is some discussions also going around that, sir, after this case has come to limelight in the Supreme Court, there is some discussions at CEC also. That's what we noticed in the paper publication. The RERA CEC is also recommending to have a revenue recovery officer in RERA department itself to implement these recoveries in RERA department. It's rather going to revenue department. So there is some discussions that definitely has triggered, after the Supreme Court has passed that important thing. Yeah.
One more question that's been asked by Chitra ji is, given the circumstances that I outlined in my presentation, how is the BBMP collecting property tax from? She's used the word home buyers. I will say from apartment players. Now, if you look at the property laws, including the latest amendment to the KMC Act, the property tax is collected from owners of building and plants. Now, remember the definition of building that I told you. How is property tax determined in case of an apartment? My understanding is this particular question is the subject matter of a public interest litigation that is either under filing or has been filed by the Bangalore City Flat Owners Welfare Association. I have raised an RTI on BBMP revenue asking, give me the gazette notification as per which you are levying property tax for apartments. They haven't answered. I have to take it up in appeal. They have no answers. This is another gray area. Why? Because the entirety of that ownership isn't clearly defined.
Yeah, I think in the interest of time, Ameya and Sudhir, can you please check out any questions being raised by the home buyers on the platform? Yeah, in between Kulukshetra, so please go ahead.
Yeah, I may appear to be in a unique situation that I happen to be a very active member of a cooperative housing society in Pune. So the benefits of cooperative society as an entity, I understand so well. We have the land duly conveyed within 4 years of handing over.
Excellent.
Excellent. And our 15,000 square meter plot lies within 500 meters of the upcoming metro station.
Wow.
So the original consumed FSI was 1. Now the FSI permitted is 4.
Yeah.
And but for Cooperative Society Act, but for the conveyance, that additional bounty would have been used by somebody else. So we are in a, now the question that I had been wanting to ask in context of the apartment situation in Bangalore, and let me mention that I happen to be a co-property owner with Mr. Narayan in so there is a thing called IFMRD, which is collected at different values. In our case, it was collected at 250 rupees a square foot, and to begin with, it was being collected by the builder directly through payment to their account. Subsequently, they decided to direct through the payment advice that this money should be transferred to another entity whom they have conceived as the maintenance provider. Now, this IFMRD being with an entity other than the builder himself, based on instruction information provided in the payment advice, how does it play out in terms of liability responsibility of the builder himself? The money, after certain number of flats have been registered, people have been subsequently advised, oh, from now on, you will transfer it directly to the bank account of entity so-and-so. Okay. And there is just a piece of an additional information that I have gone through last 4 or 5 years financial statements of this entity, because I obtained all the records from the Ministry of Corporate Affairs, records. I find that this entity shows IFMRD entries for many companies, but not for the company who has promoted my project. There is no entry at all.
So what is ISMRD? Can you explain?
IFMRD, interest-free maintenance deposit refundable.
Okay.
250 rupees per square foot.
This is again that gimmick, lifetime free maintenance on those lines. Good to see
Yeah,
innovations.
Yes, it's all innovations, new coinings.
Yeah, very interestingly, I think those who are attending for the first time and on the Karnataka Home Buyers Forum, we have a WhatsApp group where we discuss a lot of these things, and then our experts will advise on what need to be done. Please make a note of the numbers. 9535177000 is the WhatsApp number where you can reach out, and we will add you. I will once again repeat, 9535177000. If you are somebody is new into the platform, please feel free. And then we have now reached 100 apartment representation in Karnataka Home Buyers Forum. We almost close to 100 apartments within Karnataka, within Bangalore, and few apartments in Belgaum and few apartments in Mysore. So the Karnataka Home Buyers Forum reach is in major 3-4 cities, and close to 100 apartments is what the current reach in last 1 year of incorporation of Karnataka Home Buyers Forum. So that's what
Can I make one last point here?
Yeah, please go ahead.
There is this question by one Mr. Rajkumar who has queried me. He says, is my understanding correct that I am suggesting that they register a cooperative society for obtaining title of the common area and thereafter also run a KOA? So what I would do is I'm just going to show you a slide which will make things very clear. It was part of my presentation, but just take a look at the slide.
Yeah, please go ahead, sir.
Now, if you see the slide, now here I said common area title, this is the desirable end state. Common area title conveyed to the cooperative housing society, in which all owner members are co-owners. That means your membership of CHS cements your co-ownership. Members ratify and assent to management either as a cooperative society or a condominium under KOA. Now, in the case of cooperative society, my suggestion is, this is something we have to work with the registrar of cooperative societies, is that for former suggested that cooperative society be registered as a tenant ownership cooperative society. Now, what is this tenant ownership cooperative society? Now, if you see this graphic here, which is from the Maharashtra Cooperative Society rules, which lists out all kinds of cooperative society. When it comes to housing societies, they give you 3 options of cooperative housing societies. Now, what is normally in vogue in Karnataka are house building cooperative societies, which comes under serial C, And what is currently being allowed by the registrar are mainly co-partnership housing societies. In a co-partnership housing society, both the land and the building are held by the cooperative society. The title is held by the cooperative society. This may not be a very desirable model for people like us who have a sale deed, who have ownership of our apartment. So my suggestion is, when you seek registration of cooperative society, ask for specifically for tenant ownership housing society. Why? Because it's a housing society where land is held on leasehold or freehold basis by societies, and houses are owned or are to be owned by members. This is what we need.
Correct.
Yeah.
This is
Yes,
what you have to
that's
do.
precise.
But let me tell you, registrar of cooperative societies may not agree easily to this. Why? The builders don't want you to do all this.
So under the A, how do we establish the co-ownership? Do they issue a share certificate?
Yes. So in a procedure which is followed, suppose you want to make a cooperative society, you could become the chief promoter. You must need 20 more people to submit
Yes.
documents, and you must apply for registration. So what the registrar does is, he will not only look at your application, but he'll actually come and inspect your property and will determine what is the ownership share of each person of the society. Then he will tell you, please deposit this. It may be 1,000 or 2,000 rupees per owner or per member. They'll tell you to collect from these 21 people that share 1,000 or 2,000 rupees into 21, and they will tell you to deposit it in a cooperative bank perforce. And once you get a deposit made, you have to give that to the registrar, and he'll issue a registration certificate and tell you to call a general body meeting and get your bylaws ratified by them and admit more members. So this is the procedure currently in vogue in Karnataka.
Excellent, sir. I think very good point. It is 20 people required for forming a cooperative society in any apartment, and then start the battle.
Yes, earlier it was 10, now it is 20. And
20,
I suspect nefarious interest involved in raising it from 10 to 20.
Yeah.
Can you
I
please
think
show?
sir, that will raise one important question. So if
Can you-
we cannot form a cooperative society because we don't have a 20 units in an apartment, right? What should we do?
Yeah. So what happens is, in the case of RERA, your property to come under RERA, you have to be either more than 5,000 square meters, or you must be more than, I think, 8 apartments, if I'm not wrong.
Yeah.
Okay. So what happens to these people? They cannot form a cooperative society because they only 8 units or 10 units.
Correct.
In my view, in such a case, you have no choice but to go and register as a company, but get incorporated.
Yeah.
Otherwise, you will not have proper system. Somebody has asked me to flash slide 8.
Slide 9, not 8. 9.
9.
Yeah.
Okay.
So Dhananjay, innovations are already underway to make sure that exactly 19 number of apartments are kind of getting developed.
Yes. Especially private owners of land, where they can create a lot more. The developer is telling them don't develop more than 90.
And this goes on the same lines. If you deposit more than 50,000 in cash, you have to give your PAN card. So what do? You deposit 4999.
Very interesting.
Yeah. Is this a slide you wanted to see? Somebody
No,
wanted
sir.
to see?
The one which actually tells the differences between the society and association. The previous one, I guess. Body corporations. Yes.
Okay. Yeah.
Thank you.
This is it.
Yeah, thank you.
There are Supreme Court judgments, which is very clear that to create an incorporated body, you have to be registered under an act which creates such an incorporated body. And this is on the left side, you have how the cooperative society creates the body corporate. On the right side, how the company creates it. And the features are very nicely given. There are 5 features. By the name under which it is registered, having perpetual succession and a common seal, and with power to hold property, enter into contracts, institute. This is what creates a legal person. Nothing else creates a legal person. This is the only thing which creates a legal person, because you want a legal person to hold land in its own name. You want the legal person to fight cases. And similarly, in a company, you will find the same 5 things are given here. Power to acquire, hold, and dispose of property. Now, people will tell you about trusts, how trusts have land. Okay, and trust is not a body corporate. In the case of a trust, and even in the case of societies like the KSRA 60, if land is to be held, there is a provision under those acts for the land to be in the name of the trustees or the office bearer. My question to you is, would you like your land of your common areas to be in the name of one individual who is in the board?
Definitely not.
So
Definitely not.
One last question. In respect of property where the DOD is already executed, can the association go and form a cooperative society now?
So this question came up for consideration in various courts in Maharashtra. And finally, after a long period of litigation, I am in touch with some of such associations. The court directed the registrar. There is a limitation laid down in Maharashtra that once you become a apartment owners association, you cannot go to a cooperative society back again. That has been struck down in Maharashtra. And today, societies registered under Maharashtra Apartment Ownership Act are now migrating back to the Cooperative Society Act. And interestingly, for this very reason, to permit this, Maharashtra has amended the Maharashtra Ownership Flats Act and has catered for deemed registration.
Excellent.
That means if deemed conveyance.
Deemed conveyance.
If this deemed conveyance, that means if, since the property is not being handed over by the guy, the deemed conveyance and registrars have been directed. So in Maharashtra, as I understand, there are some 50,000 applications for deemed conveyance of the project of the society land into their own name and to strike it down from the builder's name. This is the protection that they have achieved in Maharashtra. We need to go the same way.
Please note that if anyone tells you that DOD has been registered and so the land has been conveyed to you as part of sale deed, please note that it is a blatant lie.
Yeah, for such people, if somebody is saying that, I want to add to what Amaya said, please ask them to show in land record. There is a land record that is maintained by the revenue department or BBMP or BDA, whichever is that. So ask them to show your name or your apartment name or your apartment association name. So either one. I don't want to see the previous landowner name or I don't want to see the builder's name in the land record. If somebody show me any apartment like this, then that's where the challenge is. Those who are claiming DOD is registered and I have a UDI or UDS, I want to see the land records of such people. If they can show me that the land record reflects their names, I will take their advices. Otherwise, please ensure that you form a cooperative society and ensure the land rights protection of home buyers.
What I would say is that when you apply for, you can apply for an encumbrance certificate, not for your apartment. Because if you apply for your apartment, it will show as unencumbered. Yeah. Apply for an encumbrance certificate for an entire lot of surveys that constitute your project. Yeah. And when we did it in our case, in my complex, it came to light that not only has our land been mortgaged, the land title papers are with a certain bank, but about 100 plus apartments for whom sale deed has been registered are also been mortgaged by the builder. And how does this happen? How can this happen? Because an encumbrance is not getting created against the larger plot of land, and the bank is happy with what is called an equitable mortgage. Remember what I told you about equitable title? Yeah. Equitable mortgage is okay for them, but in law it is not okay.
Yeah, exactly. Very good point. I think that's where, home buyers need to be aware and then make it the laws right. And a lot of, submissions is happening. I mean, yeah, go ahead.
Yeah. So the very fact that no intimation came to the apartment purchasers about land remortgage itself goes to show that there is that there was no encumbrance created as part of sale deed.
Exactly.
Had it been the case, some notice from bank or some notice from court would have definitely reached your doorstep.
Exactly.
If that is not happening, please be aware that you are in trouble.
Yeah. Exactly. And I want to give another example. I think Sudhir and Amaya, you mentioned, sir, you mentioned about your apartment in Mantri Serenity. After the apartment has been sold, the mortgage happened for Pyramid. The mortgage of the entire project land happened for SBI Capital, which is the government appointed body for running Swami Capital as well, Swami Investment Fund. So how the mortgage can happen without the consent or without taking consistence of the home buyers. So the remortgages are happening. That is the reality. If the sale deed or agreement would have registered and if it have made an entry in the land records, then mortgages cannot happen against your project land. So this is an important submission that I wanted to make, and I can prove it on record. The matter is also in the court of law in NCDRC Delhi on this matter. Yeah.
In Shobha Valley View Heritage, the land has been attached in a case of disproportionate asset against a particular individual and his wife. And because of that land being attached, sale deed registration of the owners who have bought apartments there isn't taking place. In my building complex, I on paper have an undivided share in 36 acres of land. The builder has in recent years bifurcated that land, creating a new project. And when he went to get his environment clearance, the Sika asked him, how are you coming back for environmental clearance for a land which we have already given it? So he is there. This is all efforts to doing us.
And interestingly, those Sika proceedings have disappeared from the website.
Yeah, very important thing. Probably in the interest of everyone, how this land scams happen. I want to share one document to all of you. Just 1 second, bear with me. So is it able to see this desktop?
Yeah.
So I want to show the DOD, Deed of Declaration of Mantri Serenity. You can see this. So this DOD was done on 2013 between Gokulam Shelters. On there are so many blocks, etc., right? And look at the amount being paid, 1,000 rupees being paid. And I want to show straight away into the DOD subject, right, where it has been declared as an undivided share, whatever you call it as DOD, right? Undivided share of a flat of 1,300 square feet, a super built up area. They're declaring it as 68 square feet as undivided share. And you can see these numbers, right? A flat with 1,688 square feet. So if you imagine this project is been getting constructed on 28 acres or whatever is the land, you are getting on you're declared as 88 square feet, right? And this DOD happened on 2013, and I will show you a document where the memorandum of deposit of title deeds happened, right? And I will show you the dates. You'll be surprised and shocked if the entry is made in the revenue record, how it can happen. It happened in 18 and 19, memorandum of title deeds, right? So the entire title on 2018 is being mortgaged to by Gokulam Shelters, Mantri Developers, and the allied parties to Pyramid. Okay, this is a Pyramid trust. So if the DOD if somebody is saying DOD will convey the title, then how these guys can mortgage the entire property? So please make a reading of this very important case where how the cheating happens and DOD does not confirm your title. Okay.
No, I'll say that perhaps you're not right in assuming that we'll be shocked, because we are seeing this in our Mantri Lithos project.
Oh, okay.
Right. And a very interesting insight, 2 flats in 2 different towers, each of 1920 square foot super built up area, having different UDS.
Anyway, so
And
that's what I wanted to convey to all, that, DOD is not a confirmation. Please ensure that, cooperative society is being formed, and then the title need to be transferred at any cost. So conveyance deed need to be executed. If not, a deemed conveyance need to be executed. I think in the interest of time, Sudhir sir and Subrato sir, any last touch point before I go to the slide pack to conclude the session? You are on mute, Sudhir sir. You're on mute.
I finished, but we would be very happy to engage with anybody on a one-to-one basis.
Yeah.
And we will put down facts on paper and show you things instead of just going by verbal, oral submissions.
Exactly. So we have all the records to prove what our theses or our observations through our research. And if government wants to engage us, will be more than happy. Ultimately, we want to make the law straight. And any government connecting bodies or BAF or anybody wants to touch base with us, please feel free to reach out. And our objective is, and a lot of activists, I can see a lot of ITA activists also on the panel. And everybody, I request to work together. Right, that's an important message. With that note, Subrato sir, you want to say something before I go to the concluding session? Subrato sir, our another expert panel on this channel. Yeah, Romil, go ahead.
Yeah. So I will like to check with you. I like to share with you some communications in past about 10 days or 15 days I have carried out with the Sakala authorities and the BBMP authorities.
Okay.
Pointing it out to them that there doesn't seem to have been any application of mind in devising the Khata application process. It is very, very stark. Okay, any average intelligence person would see the snafu, and gifted people, experienced people are not able to see it. Okay. And I actually try to collect a lot of references, and I use a system called Notion to put all these collections together.
Okay.
And it is very easy for me to publish them in the form of a website.
Yeah.
So I will like to share with the community here number of websites which cover some of these topics.
Yeah.
The idea being to see if this knowledge base, easily accessible, easily maintainable, can be further leveraged for this cause.
Yeah, thanks a lot. Thanks a lot, Kulushetra sir, for that open submission. And then just wanted to tell you that that the apartment Karnataka Home Buyers Forum has got a YouTube channel presence where this recording will be uploaded. And the live session today, what has been discussed, is already live on Facebook page. And we also have a Twitter account, KA_homebuyers. You can just, I will just go away from here. So you can see this is the digital presence of email ID, and then the Twitter account and email account where Facebook page. And then we also have a channel also. So all the digital platforms are ready. And also we set up a Google Drive where some of the case references will be shared publicly. And then all the memorandum that we submit to the government authorities are accessible. RTI responses are accessible to everyone. The ultimate agenda is the knowledge sharing to all the home buyers openly and honestly. So that's the ultimate thing. So I will move on to the conclusion because we already spent more than 2 hours on this channel. And let me put across, before I go to the conclusion, I request everyone to be on a video mode so that I can take a snapshot. So request everyone to come on video mode. Request everyone to be on the video mode, please. It's a very good knowledgeable audience and the excellent audience we had. Very good questions that's been asked and taken forward. The knowledge what we gain need to be percolated to all your home buyers. I know we have only representative home buyers on this platform, but this video has to be shared across everyone in your communities. That's where the knowledge will be shared across, right? So I will go to the concluding part of it. In terms of the submissions that we have made, and then in terms of what our course of action. So let me share the deck. So yeah. So let me know if this is visible. So we had a interesting debate And the topic of the debate was apartment project line title transfer not happening in Karnataka. There is no registration status. Sorry, I will change this, sir. No incorporation status for apartment association to take conveyance deed. There is no proper governing body from government on apartment associations except cooperative societies. So that's what the current status is. Problem statement. We had an excellent debate from experts. And then some of the case studies that we discussed are registered under KSRA, registered under KOA, registered under KCSA, and registered under Companies Act. These are the case studies that we discussed today. Some of the books that you can refer to is a Karnataka Societies Registration Act, Cooperative Societies Act, KOA Act, and then Companies Act. These are the 4 important books you guys need to refer to. I just took a picture and you can buy any of this. These are the best journals available that we refer to. And then, on this platform, I wanted to make a request to RBI openly and publicly from Karnataka Home Buyers Forum. Please direct all the banks and financial institutions who are approving and sanctioning the home loans to ensure agreement for sale must be compulsory registered in sub-register office. So what I noticed, I think Sudhir sir has explained very well that agreement of sale must be compulsory registered. But on the reality, is it happening in Karnataka? At least we have not seen any registration copies that is happening in Karnataka where AFS is registered. So what they're doing is they're putting as franking charges. I wanted to put across saying that, franking of AFS is not called registration. Please make a note of it. So you pay 3,000 rupees, 4,000 rupees as a franking charges. That does not make you register of the document. The builder or his representative or a GPA holder need to be present in the register office, and you need to go to registration office to get the agreement for sale to be registered. That is called registration, and franking is not called registration. And the second, submission to RBI is direct all the banks to ensure project client title reflects flat owners association name or flat owner's name to confirm undivided share of interest ownership on the land title. So these submissions we want to make from Karnataka Home Buyers Forum, because it is not only our interest but also interest of the banks as well. Tomorrow, if home buyer get default, who will own the property? It is going to be owned by the banks. And if home buyers doesn't take the, in the auctions or anything, the banks also will get into liabilities of the apartments. Please make a note of it. RBI being a governing body on all these aspects, we request RBI on this platform to ensure these 2 points, and a lot of things will be regulated in the society if this can happen. Okay, and to the government of Karnataka, we wanted to ensure to direct the registrar of stamps and duty to give directions to developers to compulsory register agreement for sale as per the government guidelines. And this is the screenshot that I took directly from the IGR website, where it is clearly mentioned agreement to sell with the promoter should be compulsorily registered in sub-register office. Thereafter, sale deed also should be registered. Please ensure franking is not registration. Please get your AFS registered as early as possible. And if you are a new home buyer, please ensure that you insist, or else please do not get into apartment without registration of AFS. Okay, this is an important submission we wanted to make. And the second one is we request the government to pass an order to concerned department and instruct the Inspector General of Stamps and Registration to notify registration of Association of Allottees as a body corporate under Karnataka Cooperative Societies Act 1959 or as a Section 8 Company Act under the Companies Act 2013. This is as now notified in states like Maharashtra and Gujarat and in conformity with the local law COFA, right? And the third request to government is pass an order to stop the practice of promoters claiming deemed registration of an association under KOA 1972 through practice of registering deed of declaration with bylaws of deemed associations. And the fourth submission to the government from KHBF is pass an order to Registrar of Cooperative Societies to issue notification to ensure all apartment associations are registered, incorporated as a cooperative society under Karnataka Cooperative Societies Act 1959. If the builder is untraceable or unwilling to participate in conveyance, the home buyers could apply to register under deemed conveyance. So this notification, we want a request. We request the government of Karnataka to take up this in the interest of home buyers. And the fifth submission is from KHPF is pass an order to Register of Cooperative Societies to bring in the required changes in the Act to permit time-bound conveyance and the builder promoters transferring the project title to association as per RERA or COFA. If the builder promoter doesn't execute conveyance deed, association should be allowed to take over the project schedule land, which the builder would have taken the FAR approval through system of deed conveyance, which is a practice in Maharashtra. And the sixth is pass an order to permit registration of cooperative society to enable migration of deemed association under KOA and those registered under Karnataka Society Registration Act 1960 to the Karnataka Cooperative Societies Act 1959 with the modifications as essential in their bylaws or memorandum to be defined the shares of the members of the association. This is very important because most of the association in Bangalore are either declared as association and through DOD under KOA or KSRA still running, and more than 70% are KSRA registered. And how do we, and seventh is direct the Register of Cooperative Societies to follow up on their interdepartmental coordination to rationalize the stamp duty payable as stamp duty already realized from the existing owners and collected, if not realized from the allottees as a schedule to membership and admission to the cooperative housing societies. This is the important point which Sudhir Pillai sir has brought up, this about the stamp duty on that. And what is the request to RERA? From Karnataka Form Boys is direct RERA authorities to ensure while giving RERA registration number to the promoter, there must be a clear directions to form the Association of Allottees under Cooperative Society Act 1959. So this is a request, humble request to KRERA saying that please, while giving a registration, your one of the clause must be registration of or incorporation of Association of Allottees under Cooperative Societies Act in a predefined manner, right? In a predefined timeline. So this is the submission we wanted to make it to care. And some other references we already brought about this. Other references, you can also read Transfer of Property Act, Real Estate Regulation Act, Karnataka Stamps and Registration Act, and the Bangalore Mahanagar Palika Building Bylaws 2003. And important link, everybody should read is IGR website, the registration of instrument related to flat and apartment. Please go through it and read what the government of Karnataka say about this. So with that note, I wanted to thank everyone who are part of this discussion, and especially Sudhir sir and Subrato sir and Ameya and Commander Surendra sir and everyone, a lot of activists who participate on this platform. And we request every activist to open up your thought process, open up your knowledge for the sake of the society. Because that I wanted to make it very clear, because now apartment are going to be, inevitable in Bangalore because of the vertical growth that we are seeing in Bangalore, right? So with that note, Maharashtra model, we need to follow because they are the early adopters of the apartment culture. And if we are adopting the apartment or flat culture in Bangalore, the law of the land also should be tailored around to ensure that we follow the conveyance, deemed conveyance, registration of cooperative societies, and then regulation body in Karnataka. And this call is to all the politicians and all the bureaucrats, all the legal fraternities, the banking fraternities, and everyone who was involved in creating the law and the policy for the people of this country and the state, request to help the home buyers on behalf of Karnataka Home Buyers, on behalf of 100 Home Buyers Association who are with Karnataka Home Buyers Forum. Humble request to everyone. And with that note, thanks a lot. Sarve jana sukino bhavantu, sarve santu niramaya anta ಹೇಳ್ತಾ ನಾನು ಇವತ್ತಿನ ಕಾರ್ಯಕ್ರಮವನ್ನು ಇಲ್ಲಿಗೆ ಮುಕ್ತಾಯಗೊಳಿಸ್ತಾ ಇದ್ದೇನೆ. ಜೈ ಹಿಂದ್, ಜೈ ಕರ್ನಾಟಕ. ನಮಸ್ಕಾರ ಸರ್.